Thank you very much. Can everybody hear me up the back? Great. Look, I've had a fabulous day today. I think it's just been a wonderful set of presentations with really engaging speakers. Our time is so precious and so valuable, and I think I certainly feel that coming here was very, very worthwhile. So I'd like you all to join me in thanking Tina and the Centre for putting on today. It's been a great effort. Thank you. So, my job, I guess, is to deliver the concluding remarks, and I noticed that, as you would expect, there were areas of agreement and areas of difference. I was surprised there was quite a bit of agreement throughout a lot of the presentations. I think one thing that we probably all agree on, whether you are a medical practitioner, a legal practitioner, whether you're an academic, whether you're a regulator, is that the health and safety of the public is paramount. Obviously, that's where medical practitioners start from, and obviously that's where the regulators also start from. And so I found it interesting then that there is a social contract there where we allow professionals to rip our chests open and to saw into our shin bones, as we heard earlier today. And we allow medical professionals to do that to us, and in return they are remunerated for that. And we expect that the service that they deliver to us will be within the professional boundaries. And we expect that that amongst the cohort of people that are privileged to provide that service, that we don't have people that are wildly addicted to drugs or are sexual predators and engage in that sort of conduct. So we see both sides coming in there, from the practitioner side and from the regulatory side. In terms of innovation in this space, there was discussion around what is innovation and a struggle to define it in any meaningful way. I liked the definition we heard about, that it's a virtue, that we're looking for better patient outcomes. I thought that was a neat description of what medical innovation should look like. And indeed, when it is done that way, innovation would be promoting the public health and safety, because it would be providing those better outcomes. However, we also heard plenty of stories about innovation which goes the other way and undermines the public health and safety. So we heard talk about rogues, cowboys. But then when we looked into it a bit more deeply, we saw that the reality may not always match the perception, that it is perhaps the fear of regulation or fear of discipline that is somehow stifling innovation. There was a struggle to find real concrete examples of that occurring. We heard about, in the sphere of innovation, which perhaps tends to undermine public health and safety, we heard about autologous stem cells and the use of science-ness to attract customers. There was discussion about the regulatory lag, and there's obviously some work in that space for the regulators to do. And certainly, without giving any undertakings, I've spoken to a number of the speakers, and I'll be going back and talking to the Health Ombudsman about this space. It is something that in Queensland we are aware of, but it warrants further conversation. And there was discussion around, well, what is the right response there? Is it a code? And that would certainly be a great step in the right direction. And then there's also the enforcement of that code and the whack-a-mole sort of approach. And I think ultimately, any sort of, at the pointy end of regulation, it does come down to whack-a-mole, which mole is not following the code if we have one. And the benefit of whack-a-mole is that when you whack the mole, that particular mole doesn't stick its head back up again. That's the principle of specific deterrence. And that mole hopefully goes and tells all the other moles, hey, don't stick your head up. And that's the principle of general deterrence. And that's the basis on which we regulators work, if it's done well. We heard horrible stories about the artificial larynx. And we heard discussion about, in the bad innovation space, about rogue GPs. And certainly in our office, we do have an example of a rogue GP. I can't go into the details, but that is certainly a very spectacular example of that, of the dangers of GPs using the internet to inform their treatment of patients. Even though the patients really, really wanted the outcome, it was clearly not going to be a good outcome, and it wasn't. One thing we didn't talk about is now in Queensland there is an unregistered space. And it's a very, very vast field. It covers a whole range of previously unregulated professions. And I think that that's another big cohort of bad innovation, the potential there for the quackery. And we actually do come across quite a bit of that. And so things like people that are suffering from cancer and turn their back on conventional treatment, they'll turn to the internet again and often reach out to anyone that offers them a way out of that. And so, for example, I don't know if you've heard of a substance called black salve. It's a very caustic substance. If you Google it, you'll find some horrible photos on the internet of what it does to you. It just burns through your skin. And so that's something that our office is dealing with, the unregistered sphere using black salve to treat people, which is unfortunate. Some very bad outcomes there. And so there was a comment made that perhaps in relation to this fear about regulation stifling innovation, that perhaps the issue is more the inappropriate conduct rather than the innovation per se. And certainly that rang true for me from my experience in the field. And that's not to say that the perception isn't real. I think obviously it is real. And it is something that we need to keep in the forefront of our minds. There was another theme that arose about innovation being stifled, not just from the discipline side, but from the civil proceedings as well. But as we moved through the day, I think most of the discussion was about the disciplinary space. And certainly some of the early speakers spoke about the fear that medical and other practitioners have about disciplinary proceedings as opposed to civil proceedings. And perhaps one reason for that is under disciplinary proceedings, you are the target of the investigation, whereas in civil proceedings, whilst you're certainly a party to it, ultimately your practice won't be affected. It might be affected in ancillary ways, but it won't be directly affected as a regulator can do. So perhaps that's one reason for the fear. We discussed the legal framework, the national law. It's quite a big document. It's despite its title, it's not a Commonwealth piece of legislation. It's uniform state-based legislation, which is not uniform. Because New South Wales and Queensland are a bit different to everywhere else. We all agreed across the board that when you look at the figures, it's only a very small proportion of practitioners that actually end up before a tribunal, and that seemed to be consistent. In Queensland, I managed to get some statistics from our office. So from this January to the January before, we received 6,394 complaints. From those complaints, we've launched 389 investigations. Of those, about 1 in 6 is currently paused pending criminal proceedings. So about 1 in 6 of our investigations actually arise from criminal charges that are laid. There have been 48 matters referred through to me in my role of Director of Proceedings. My role is to decide independently of the Health Ombudsman whether to refer matters into the tribunal or not. So 48 matters, and of those I've referred 15 matters through to QCAT. I've referred 4 matters back to the Health Ombudsman for further investigation, and in one of those matters I recommended no further action be taken. And I've currently got 29 matters under consideration in various stages. Some have just been received in and some are about to come to me for the final decision. And then finally, perhaps one of the points of difference, which would be as you would expect, from the practitioner's side, the concern, a very real concern about delays in investigations, about a perceived lack of transparency and fairness. And then in conversations out in the courtyard, a bit deeper about the problem that we have, the issue that we have with splitting the cases in Queensland. So where we have a practitioner who's engaged in perhaps misconduct but also has health issues. In Queensland, we've been tending to give the health issue to ACHLR to deal with, and the Office of the Health Ombudsman keeps the conduct issue. And there are reasons for that, good reasons for that, although it's obvious from the feedback that that's probably not the best way to deal with it. The good reason is that our office lacks powers to meaningfully deal with health issues, in the sense that a practitioner with health issues sometimes needs a lot of support through various assessments and panels that can be set up, or alternatively that the health practitioner is continuing to perhaps engage in drug use, and as we take the matter to the tribunal, we would like to perhaps get some hair testing to see whether that drug use is continuing. We don't have those powers, so that's why in Queensland we've ended up splitting complaints, and I think that's a matter for Parliament to sort out. There has been a recent inquiry into our office by the Parliamentary Committee, which is charged with overseeing us, and we put up about 20 pages of suggested amendments to the Act, and one of them is around that, about our office getting those extra powers so we can keep matters together. On the other side of the coin though, from the patient and the public point of view, if somebody is engaging in serious misconduct, well then that is an issue that needs to be dealt with. It's not just medical and other health practitioners that go through disciplinary proceedings, it's also lawyers. So for example, I can have a complaint made to the Legal Services Commission about me, and because I'm a public servant, I can have a complaint made to my boss about my behaviour as a public servant, so I'm subject to two separate regimes. There are teachers, there are builders, and even real estate agents are subject to various regimes. So it's not just the medical practitioners that are subject to this, but clearly it's in the interests ultimately for the protection of the health and safety of the public that whenever the regulator steps in, that it's done in a very fair and in a very timely manner. And I think that's a point of agreement as well. So those are my concluding remarks. Thank you all for attending today. It's, like I say, it's been a great day, and thank you for all taking time out of your busy schedules to attend. Thanks, Tina.